This course I have described this as an introduction to legal skills. I've also said that skills follow knowledge. Okay, so I'm giving you knowledge here, which will work out to be also skills, as you'll see later. But so bear with me a little bit because I'm going into a little bit of legalese here, and I'm almost nervous to do this because it's actually, again, it is a complicated topic which I've tried to get to very much the basic ideas so that it will help you in your role as a representative of either party or involved advising people and that kind of thing. So you need to have this kind of understanding. It's about this question of jurisdiction. Okay, so jurisdiction means, I should perhaps put it out there, but it's legal authority. It's the authority in law. That's what jurisdiction means. But in order for there to be, to advise people what to do, there must be a cause of action. So somebody comes and tells you a story, a version, as I keep saying. What you do is you listen to it and then you say, okay. Now, from the knowledge that you'll gain from this course, you'll be able to say, yes, you have a cause of action. That means that there is a piece of legislation, a regulation, code of good practice, sectoral determination, which applies to that situation and gives a ground or reason to apply to the CCMA Council for a remedy. All of those words are important. That there will be legislation. We've looked at legislation. I've showed you how to read it and find it, etc. And then the question of where do you go? The CCMA and Bargaining Council is what I'm really aiming at. Court. Okay, we're not talking so much to lawyers, but to somebody who's, if we say, a layperson. Okay, and then for a remedy. Now those words all important, and we'll unpack all of that later. But there's this idea that there must be a cause of action. So it means that, for example, the CCMA must have jurisdiction, legal authority over the cause of action in order for the dispute to be heard by the CCMA. Does that make sense? There must be jurisdiction over the cause of action. So, for example, as at a very basic but fundamental level, and this is also why I'm raising it, because people get this completely wrong, is there has to be an employment relationship between the parties. That is, an employee or union, an employer or employers. And what we say, employment relationship, for the CCMA to have, remember what we said, jurisdiction over the cause of action. If there's no employment relationship, then there's no jurisdiction. So, for example, the Labour Relations Act has been written with the notion of resolving disputes between parties in the employment relationship. The whole, if you'll unpack it as the more you get used to it, but it's almost like this, that at the end of each section, or sometimes a part, or certainly at the end of the chapter, there'll be a section that says something about disputes in this section, and then it tells you the process to follow. So some would be straight to the Labour Court, some would be to the CCMA, some would be CCMA or Bargaining Council, some CCMA only. Okay, it tells you what to do, which is very helpful. But that's all within the notion that there is an employment relationship. So while the Labour Relations Act is set out to resolve disputes, not all disputes. So if you have a dispute with your neighbour, your neighbour throws rubbish over your wall, or whatever, or with your wife, you're not going to go to the CCMA. Why not? Because the CCMA doesn't have jurisdiction over the cause of action. Why not? Because the dispute is not between employer and employee. That's why this is so key. And this is why I'm raising that, because in my experience, this is where people get completely confused. So we call that now jurisdiction over the parties because of this employment relationship. So there's jurisdiction over the cause of action. the nature of the dispute, the issue in dispute, and then the parties. So these are some of the disputes over which the CCMA, Bargaining Council, Labour Court, etc. have jurisdiction. Unfair dismissal, unfair labour practice, strikes, as an example. Okay, so let's just make sure we understand. The jurisdiction is related to the parties, employment relationship, cause of action, and then a remedy. Now, a remedy means that if you went to the magistrate's court and said that, no, my employer has dismissed me, the magistrate's court would dismiss your case. Not because you're not telling the truth or anything like that, but for the reasons I've given you, but also because the magistrate cannot give you a remedy, cannot give you a legal solution to the problem that you're bringing to the magistrate. So the remedy is part and parcel. You have jurisdiction over the case because you can give a remedy. So in labour, if you've been unfairly dismissed, your remedies are, and they're limited. But they're limited to reinstatement, getting your job back, re-employment, getting your job but another job with the same employer, or compensation. That's it. So, for example, if in the process of dismissing you, the employer defamed you and your family and whatever, well, the CCMA doesn't deal with that. It deals with unfair dismissal. If you want to take that on, that's when you go to the magistrate's court, because now you're talking about defamation, etc. So not talking about dismissal law. I hope you understand that. So there's a question of remedy as well. Okay. So here's a little, just test your understanding of what I'm talking about. Is that a fellow employee tells you he's been charged with misconduct. The hearing is set down for 2 weeks' time. Listen. Hearing is set for 2 weeks' time. We ask you, you should go straight to the CCMA because he says, now I'm innocent. What would you advise and why? Make sure you understand what I'm asking you. Would you say, yes, you must definitely, your case is wrong, and the employer is completely unfair, blah, 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 blah. What he's done to you is wrong, well, you must go straight to the CCMA, forget all this thing. So what is the answer? The answer is that he can't go to the CCMA. Why? Because he hasn't been dismissed. He said the hearing is set down for 2 weeks' time. He hasn't been dismissed. He hasn't told you that he's just charged with misconduct. All right? So why? And then why would you advise him not to go to the CCMA? That he cannot go to the CCMA, or he can, but then they'll tell him to go away. But because of jurisdiction, the CCMA has no jurisdiction unless he's actually been dismissed. If that is his case, the dismissal has the CCMA has no jurisdiction. Good. I hope you understand.